there is so much delay, even for people applied way back in 2023, yet to receive the date for hearing? Why is that?
Yeah, there are a lot of different reasons behind those delays, and we are seeing that happen quite a lot as well. So, still dealing with cases from 2023, 2024, and so on. There's a number of different factors. So, there's not really one answer that explains it all, but there's different things that happen at the same time. So, for example, and some of these are things that we've been told directly, or I've been told directly from the refugee board. Some are things that we kind of just see and understand based on the industry. So, for example, some of the factors, for example, the immigration IRCC agencies, CBSA, these types of ones, they've had changes to their workforce. So they've either let go of people, cut down the workforce, which of course means that there's more work for fewer people to do. There's those changes to federal agencies. In 2023, we also noticed that a lot of cases, particularly from countries that were higher risk, or if the government deemed that there might be a higher risk, and really just across the board, conducting more background checks into people. And so, of course, those are things that they handle on their end, conducting those checks and screening and so on. So we're seeing increased delays from that, and including cases which may have been ready to proceed and to be scheduled by the refugee board, because they had to go back into that screening process. That caused a delay too. So, and then separately from the things that we've heard through, for example, with the refugee board, and this is something that I heard from them back in October, was that they're dealing with an incredible backlog of cases, obviously. They'd mentioned that at the beginning of the fiscal year for last year, they had something like 170,000 refugee cases still pending, and that they aimed to get through at least 85,000 per year. So to me, what it seems like is that obviously they've got a limit to the amount of cases that they want to process. So that could be both intentional, just to kind of slow and ease things down because of the pressures that they're seeing, the backlash that they see as well. Obviously, across the world, not just here in Canada, but across the world, there's been this kind of turn against immigration, and even against refugee claimants and so on. So these are sometimes people in like the most vulnerable situation where there's no one to actively protect them, and it depends on what the government does. Um, so in this case, I see it as being like they're targeting in a sense of trying to reduce the amount of people that they're accepting by delaying the cases, because they know that once a person's in Canada, they're already free, hopefully, from the harm that they're facing. So even if the case takes a bit longer to process because of some of these other issues and also just the delays that are taking place, they don't. I think they don't really see it as being a big issue for the refugee claimant themselves. That this added delay, when compared to other places, like for example in the U.S., where people used to wait up to a decade for a decision, sometimes even longer. From the Canadian side, I think they've kind of thought that people waiting 2-3 years comparatively to other places is not as bad. So that's just my opinion on it, and I think there are elements where they've had actual issues where they've had to deal with these processes and changes to the processes, and also their own kind of internal policies of actively slowing things down to a more manageable level.
In October, after the comprehensive overhaul by the IRCC, there was information saying that those who apply for PR, especially after being selected as a protected person, after granted protected person, they have to wait up to 99 months or something. But there's a change. Is that correct?
Yeah. So that has changed, and even when the government did that thing of like when the processing times on the website changed to the 99 months or whatever, I was also telling people that, look, I think this is a temporary thing. I don't anticipate seeing them take 8 years or whatever to process PR applications like that, and so it has come back down to what it was before. In some cases, a bit quicker as well. I think it's now around 16 to 18 months, or 16 to 24 months, depending. But it's at a more reasonable level now, and the government did. It was one of the things that I believe was in the budget as well, where they said that they do want to actually speed up the process for people who are already here, or at least to streamline it a bit more. So I think that the waiting times for that will reduce, particularly in the long term, when we see that the government again is reducing immigration targets, reducing issuing new PR applications to people who are outside of the country and so on. So I think we're seeing those changes. If Canada's population growth continues to go in the negative, I it kind of makes sense to give status to the people who are here already. But again, those are the things that it really just depends on how things go down the future. It's not a guarantee by any means, and even these processing times that they're given right now, they're just a guideline. So something could happen, a month from now, a year from now, that suddenly upends the current processing times because of some other unforeseen event. So all of these types of things, they can change very quickly, and they depend on the conditions at the time. And I see it kind of happening in waves. There's times when immigration rules get very strict, then there's times when it gets relaxed a bit. Um, as an example, like in Europe, where again other countries are getting more strict, we just saw the other day where Spain actually gave a significant number of people who were undocumented, gave them some form of status, kind of like a clemency thing, and recognizing those people. And again, different conditions. A lot of those people are from Latin America and have ties to Spain through family and so on. And there's a cultural connection and so on. So we see similar things happen in other countries too, and it just depends on the circumstances. But right now, obviously, the bottom line is yes, people are having to wait longer, but the process itself and the fairness that's behind it still remains.
Those who applied for asylum, when they applied the initial stages, they were provided with a work permit. So before they get the hearing date, somebody's work permit might expire. So in this case, are they in a dangerous situation, or what is the advice you would like to give for them?
Gotcha. Yeah, so they people definitely can. If you have a pending refugee claim, you definitely can apply to extend or renew the work permit. There is a website on the IRCC webpage itself, which is an application to change or extend the conditions of the work permit. Which if you type in like refugee claimant renew work permit, there'll be probably the first link that comes up. And so within that, it's an online application, relatively straightforward. There is ordinarily a cost of $155, I believe, for that, but refugee claimants who, again, have existing refugee claims will be exempt from paying that fee. And they do have questions that you can answer to see which position you're in, because it depends on what stage your case is at. That has an impact as to whether you're eligible to renew and what the cost could be if you do have to renew it. But it's a relatively straightforward process, and certainly if you have a pending claim and your hearing hasn't yet happened and you don't have a decision yet, you can renew it, and the renewal has to be done 3 months before the work permit is going to be expired. But I mean, even if you do it a month before, doesn't matter so long as you get the renewal in before the work permit expires. That's the most important.
Some of the people who arrived in couple of months ago, about 6 months ago, I heard this, they received letters from IRCC that to submit their documents, and they said they need a consent to go without hearing. What is this? Please explain this to me.
Yeah, absolutely. So these are, they have different names. It's called the file review process from the Immigration Refugee Board side. Some people call it the less complex letter. It's a letter that the Refugee Board sends out, basically saying, look, we've selected your case, and if you give us your evidence, we will review it and then decide either to accept the case without a hearing, which is a file review process, or to issue, to proceed with either a short hearing, which is just, it's a 2 hour long hearing as opposed to a 3 hour, or a regular hearing. In reality, between a short hearing and a regular hearing, it doesn't make much of a difference. Even a short hearing can take just as long because there's admin processes and so on that happen on the day of the hearing. But generally, it gives a person an indication that their case is relatively straightforward, and if the board member believes them, there's a good chance that their case could be accepted. So the less complex process, it does exist. One thing to note, and things that we've heard, is that generally refugee cases that are picked from that, it may be an automated system. Like, it might not necessarily be someone who is actively looking at the case and choosing it. And so that's why they tend to send out these letters kind of en masse for different countries. And in my view, and this is just my own opinion, I think of it and I see it as a way for the board to kind of encourage people to send in their evidence early. But the letter does state, and it's something that I remind people all the time, it doesn't mean that your case is going to get accepted any sooner. It can, and sometimes it does, but a lot of these things, just like any kind of bureaucratic machine, it depends on a number of different factors. It depends on, is someone actively reviewing your case? Has it maybe gone to the bottom of the pile? And so these things, a lot of stuff happens behind the scenes, and they have different teams working on different files and cases. So it doesn't mean that the case is going to be accepted any sooner. It just means that there's a possibility you may not have to go to a hearing. But I still tell people, even when you receive this letter, unless the case is so straightforward and simple, and there's not many legal issues that come up, you should always expect that there is still going to be a hearing, because in most cases, I would say over 90% of cases, there is a hearing. And you're expected to answer questions with a board member and to explain why your case, the merits of your case, and why it should be accepted, and so on. So people should still have that view that there or the expectation that there will be a hearing, but that if they provide evidence, strong evidence, which is good, things to back up their identity and so on, that it can help smooth the process over. Yeah.
No, in the worst case scenario, if a person's asylum case is denied or rejected at the first instance, what are the available option, next steps? What are the ways they can go? One by one, you take us through what will happen after the rejection. Where should they go? Then what will happen? That got rejected. To take us through a journey.
Yeah, for sure. There's different things that can happen, because it depends on, for example, it depends on how the person entered the country. If you entered the country at the border with the United States, and if your claim was made as an exception to the Safe Third Country Agreement, which we have with the U.S., then your options are a bit more limited, because if you lose your initial case at the Refugee Board, you can't file an appeal to the Refugee Appeal Division, which is the next stage up. Instead, you have to go to the court, to the federal court. But ordinarily speaking, this is just like the average refugee case. So if you made a refugee claim, and if your case was denied for any reason, and there can be a number of different reasons why, they can either reject it because they don't believe you, or that they don't believe your identity, which is rarer, but it can happen. Or you can be believed but rejected for some other reason, because they think maybe there's some safety in another part of the country, which can happen at times, particularly depending on the country. And so there's a lot of different things that can happen in a case which causes it to be rejected. The usual stage is that you can appeal to the Refugee Appeal Division. There are time limits involved, and those time limits are very strict. If you miss the time limit, then that can have a knock-on impact on, for example, whether you can be removed from the country. So if you appeal a negative decision on time, then usually, and depending on the type of case, that can prevent you from being removed from the country, because they have to let that appeal process go through without just removing you from the country, right? Because what if the decision was wrong, and you're already removed from Canada? It kind of makes the whole process a bit pointless then. So long as an appeal is filed on time to the Refugee Appeal Division of a negative decision, you can benefit from a stay of removal, meaning that they won't remove you. The time limit, generally, it's 15 days from whenever you receive the decision. The Refugee Appeal Division kind of assumes and gives up to 7 days for a person to receive it. But of course, nowadays, because they issue the decisions, particularly if a person has a lawyer, or if they're registered onto the government's, like the My Case portal, then you receive the decision pretty much instantly on the day that it's issued. But the general rule is 15 days from when you discovered the decision, and then after that, there are other deadlines that apply to appeals, because you have to file documents in support of a case, and usually again, those deadlines are set out. It was 30 days before, but sometimes you can also get a bit of extra time and the Refugee Appeal Division will actually issue a letter, an acknowledgement letter, which gives the exact deadline that you have to submit the documents by. So with appeals, it's always best to get a lawyer to consult someone, because those are very complex processes, and particularly with the Refugee Appeal Division, most of the time it's a written based appeal. Sometimes there can be hearings, but only in very, very limited circumstances. Um, so sometimes you don't even have a hearing. If you lose at the Refugee Appeal Division, or if you weren't allowed to go to the Refugee Appeal Division for any reason, then the next stage is to go to the federal court, and so that is an application for judicial review, where you're essentially asking a federal court judge to look at the case and to decide whether it was reasonable or not, whether it was a fair decision, or if there are any issues, like maybe they didn't take something into consideration, or maybe there's some error of law that's in the case. So there can be a number of different reasons to file that kind of application, and so that's the stage where it reaches the federal court. That process right now is taking a very long time. The federal court is overwhelmed and dealing with a high level of cases as well. So that process, sometimes it can take a year. It can take sometimes even longer. The important thing with that is the court can only look at, generally speaking, the existing evidence on the file. So at that stage, you can't really introduce new documents or new evidence. You're restricted to arguing whether the documents and the evidence that was before the board member, whether they made a correct or reasonable decision in light of all of those documents, and in light of all of that evidence. So the federal court is at that second stage or first stage, depending on what happened with your refugee case. If you lose that, and if the judge dismisses that case, then, to be honest, by that point, your refugee claim is done. There are ways to, before a federal court makes a decision, you can apply for, a reconsideration of your refugee claim. Those are, again, very limited circumstances, and it depends. Let's say if someone didn't help you properly, or if your procedural fairness was violated for some reason. Let's say they scheduled the hearing, but they never told you about it, and then they dismissed your case. That can be a reason to try and get the case reopened. Again, very rare, but it can happen to some people. So if the federal court dismisses the case, though, that basically means the refugee claim is done. What happens then is there's usually a 12-month bar which prevents people from applying for a pre-removal risk assessment, which is similar to a refugee claim and has similar aspects that are considered, but those cases are decided and processed by the CBSA, by the Canada Border Services Agency, and by their agents, and also by IRCC Immigration. That also kind of works with the CBSA. They work together in a lot of cases. And so even with the PRA, you cannot file a PRA after your refugee claim is rejected unless at least 12 months have passed from the time when you received the final decision. And generally speaking, you can't even rely on the previous allegations. And depending on, what the case is about, they only look at new evidence. There is also the ability to apply for the H&C Humanitarian and Compassionate Grounds PR application. So it's basically, you're applying for permanent residency, saying that you meet some kind of exception to the rules. And again, there are limits and things that restrict who is eligible to apply for those. And actually, right now, because of the incredible, the processing time for that is nearly 10 years, I believe. The government's basically saying they're not going to bother processing those applications right now. It's not really, from my view of it and my opinion on it, is that they don't see those types of cases as a priority right now for them to deal with in light of all of the other challenges. So a person can still apply, but whether it actually gets reviewed by an IRCC or immigration agent before they try to bring removal proceedings against someone, that's a separate question. So at this stage, it's a bit more restrictive in terms of what options are available if a person's refugee claim is rejected and if it's dismissed even at the federal court level. But there are still things that can happen, and safety mechanisms in a way to prevent people from being wrongly deported to a country.
That there is a kind of a doubt or fear that those who receive Ontario works after they submit their asylum claim, because you find there's a lot of people find it difficult to find jobs. They go for Ontario works for the help. So if they are under Ontario helps my benefits, there's a chance their case could have been negatively affected because they are dependent on the government funding. Is there any connection between the two?
In terms of a refugee claim, no. The short answer is no, that it doesn't have or it shouldn't have any impact. Um, Depending on the circumstance, of course, but generally speaking, when it comes to a refugee claim, the board member is only looking at whether a person faces a risk in their country of origin or citizenship. So it's very rare, and I don't really see a case where a person's work status in Canada would have an impact on that. It can obviously, there are times when it can have an impact on a person's, let's say, credibility, maybe in limited circumstances. But the short answer is no, it shouldn't really have an impact. Um, Sometimes, the refugee board will ask if a person can go back to their country, and the board member will want to find out how capable that person would be. Now, if that person has managed to be successful here in Canada and has done a number of things, in a funny way, that could actually be used against them to say, well, you've been successful here in Canada, so I think you can be okay if you go back. But again, that depends on the type of board members that are deciding cases and how they view certain cases. And there's also other board members who will ask the question and say, are you working in Canada right now? Which technically is not really a relevant question. But some of them, obviously, they do like to see if a person is managing to integrate, is managing to contribute in that kind of a way. But the fact that a person isn't able to work, or if they're receiving benefits, it shouldn't detract from their case. Everyone has different circumstances. Some people try and find work and can't, maybe because of language issues or whatever the barriers are. And of course, right now, there's a number of people who are having difficulty with work. So that doesn't really impact a case. What I think of more so is, so long as if a person has a refugee hearing, and let's say if it's 2 years after and they've been in Canada for 2 years, in my view, yes, of course, it does look, it has a better appearance if the person has been working and whatnot, or has managing to show that they're integrating, or let's say if they're taking English lessons or attending school or something like that. I think that most people like to see that because it shows that the system is working and working well to help people integrate. But a person shouldn't have a consideration if they haven't for some reason, or if they are reliant on Ontario Works. That service exists precisely for people who need it, and a person shouldn't restrict themselves from applying for that service which exists if they need it. Just because they're worried that it could negatively impact their refugee claim. Now, on a separate thing, just to note, it doesn't really impact refugee claims or pre-removal risk assessment applications, which are looking at risk only, right? So those types of applications, the decision maker is only looking at what's the risk that the person faces if they were to leave. So it doesn't have an impact there, but it can impact things like H&C applications, right? So if a person is in Canada and has made an application for humanitarian and compassionate application ground, sorry, there can be instances where if the person is on social assistance in some way, that the officer uses that against the application to say, this person isn't really integrating into Canada, hasn't really, managed to support themselves and so on. And so they can look at that, and they do look at that in very crucial lens. So it can negatively impact that type of a case, right? Just like it can also prevent people from applying for sponsorship, for example. So it can have impacts on other types of situations, but not on the refugee process directly.
About 2 million um, temporary residence visas are scheduled to be expired this year.
Mm-hmm.
So, what is the, those are especially the students, temporary workers, those kind of people, and even some refugees also. I don't know, but could you explain what are their fate?
Yeah, well, obviously, I mean, if a person's in a country and that status is expiring, I mean, you are expected to uphold the rules and conditions that apply to that. So, in the vast majority of cases, and I think based on I can't remember where I read it, but in the vast majority of cases, people do abide by those conditions, because not everyone is in that same type of situation or whatever. And again, most people do not want to fall foul of laws, including immigration laws. Um, Even just overstaying by a day can have an impact depending on your situation, right? Other countries, for example, actually fine people for overstaying. So there's a lot of different, in the US, for example, or other countries as well, you can end up in jail for that. So, and not, no, that's not to say that that can't happen here. There are situations where that can happen here, particularly if the CBSA is trying to remove a person from the country who has overstayed. But there is a process, right? So, yes, people are expected, if their status is expiring, that they abide by that and leave the country. And I don't doubt that most people in that situation would. I think even looking at international students, not only here in Canada but in other countries as well, the vast majority of students go to the country, study, and then leave and return back. Because that's just how the system works, right? And there's always more opportunities that can come in the future. Now, of course, if a person has a fear for their life and doesn't want to return, that's a separate situation, and one can understand. The government may also, immigration, just like anything else in life, is partly dependent on luck, kind of a lottery game in a way as well. There's certainly skill that's involved, and people have to do a lot to get through these processes. But as I mentioned, I think earlier as well, if the population continues to decline in Canada, so like what we've seen recently, in my opinion, there's only so long that the government can maintain negative population growth, because that decline would start to impact the economy and just a bunch of other issues. So I think, yes, they're obviously stopping or slowing down the number of applications that they're approving and allowing new people to enter into Canada. But for the people who are existing here at the moment, um, I think, one, if you're in Canada and you don't want to leave and you still have valid status, obviously, carry on doing what you're doing in terms of working, integrating, and so on, and wait and see, because applications may open up in the future, which suddenly a person could be eligible for. There's a IRCC website which actually shows all of the open immigration programs, and there's a short questionnaire. I believe it's called Explore Immigration Programs in Canada, and it's a great little tool because it shows you can answer a bunch of questions and it'll show you which different things you're eligible for, and those things change all the time. Just going back recently to examples from during the COVID-19 pandemic, that was something that happened. No one predicted that pandemic. It happened, out of thin air. And the disruption that it caused was significant. No one could enter Canada for a significant period of time. We had a long period where absolutely no permanent residents were being entered in. Um, and so the government at the same time instead did these other programs, like for construction workers or for pandemic and healthcare workers, right? So new programs opened up to address specific issues. And in my view, if the population continues to decline, um, we do need people at the end of the day for the services and everything that we offer, and to keep society running. And I think, given that they already have a number of skilled people in the country, like just when I look at the express entry draws and so on, the numbers are significantly high in terms of the points that people have, and that means that those are incredibly qualified people who are already integrated in Canada. I think it would be a bad idea for the government to, um, you know, not help those people if they wanted to stay, and if there was a demand here for it as well, to not find some kind of agreement to make that need get matched in a way. But it is one of the things where we do have to wait and see. A number of things can happen, and I don't doubt that people, if their status is going to expire, most people, if they don't see an option going forward, obviously will have no option but to leave, because it's very difficult to survive if you don't have status, right? There's many obstacles that people face, and for some people it's simply not worth it.
Like you would have seen hundreds of cases in your career, maybe could be thousands of cases. There are also concerns expressed in Canada. Those who apply for asylum not really have problem, but they have economic problem. They are economic refugees. So in Canada, under which categories a person can apply for asylum?
Yeah, absolutely. So, in terms of the cases that we deal with, because the applications are made under what we call Section 96 and 97 of the Immigration and Refugee Protection Act, so that's the law, a person can only make a refugee claim if they are fearing persecution in their own country, or if they're someone who is in need of protection because of a risk that they specifically face. So, economic reasons, generally speaking, do not rise to that kind of a threshold. If a person entered Canada and said, "Hey, I'm making a refugee claim against my country simply because I can't find a job and I'm not earning enough," that case would get rejected. Right? It would go through the process, but it would get rejected, and unless something else came up that showed that the person had a risk. So they really just look at risk profiles. Now, obviously, there can be instances where people will lie or fabricate a story because they've really escaped for some other reason, or because of economic conditions and so on. But that's for the refugee board to decide based on the merits of each case. But at the same time, if a person is saying that they're afraid for certain reason, the board's job is to assess and to analyze that case and see if they really are afraid for that reason. So yeah, in my view, we don't really see many cases, or really at all. It's very rare for us to have inquiries like that where a person's saying, "Oh, look, I'm an economic migrant and this is why I can't go back." Usually, there's some other reason that's caused the person to flee. Um, so yeah, so we don't see that as often. And I'll give you an example. Well, I'll try and give an example. I guess there are countries where economic crises have happened in the past. Usually, when those crises are happening, people can't even leave from those countries. When that's happening itself. And often people who do leave or who do manage to get out are ones who have visas to Canada, or family here or connection already, because Canada is a country that's actually very difficult to even reach. You usually have to pass through another country just to get here, and so it's very difficult for people to get here. Sometimes the people that do arrive are people who do have some money and were lucky enough to be able to get out. So I think sometimes people have this idea in their mind that refugee claimants who have fled from their country um, don't have any money, or are fleeing, and are fleeing those types of conditions. There's such a variety of different cases, and everyone has their own situation. Sometimes a person can also have money in their country, but because they've had to flee at short notice, they don't actually have access to those things anymore, and suddenly they find themselves in a new country and kind of starting from the bottom, having to seek out legal aid and so on, or whatever other assistance, precisely because they could be rich in their country, but they're not as wealthy or affluent here, and so they're kind of forced to go through those processes too. But I wouldn't label that person as an economic migrant or anything either. So yeah.
The what is this situation with the much feared Bill C2? What is happening with that? What is the base of that bill? Why is so much of fear expressed about that?
Yeah, so there's been a lot of, especially when it first started circulating online and people spreading things, and even stuff that I saw, there is a lot of maybe not disinformation or misinformation or whatever, but there is some misunderstanding about this. So it is a bill that the government has put through in the parliament, but it's still going through that stage. So it's going through debates and different readings and stages that they have in the parliament itself, where the MPs, the people that we elect, they argue and debate over the legislation itself and the laws. So C2 was introduced at first, and there's a number of things that it raises. For refugee claimants, some of the things that are most important are these new ineligibility provisions. So conditions that can arise that can make a person ineligible for making a refugee claim. The time limit, the 1 year time limit, is one of the things that it introduces. It's effectively saying that if a person has arrived in Canada, they have 1 year to make the refugee claim. But because of the way that the law is worded, it's facing a lot of pushback. And again, one thing I'll just start off by saying, This bill, and there's actually another one as well, which is even more important in my opinion because it takes the elements of Bill C2. The other one is called Bill C12, and that one is actually, it's also currently in the Parliament, and they're debating it. They're arguing over the bill. It's actually gone further along than Bill C2, and it incorporates the main parts of Bill C2, which are going to have a big impact on potential refugee claimants or those who are already in the system right now. So Bill C12, which has a similar kind of name, it's an act respecting certain measures relating to the security of Canada's borders and the integrity of the immigration system. So there's a number of things that are in there right now. It's passed through the House of Commons, so it's passed through the lower house. They've basically agreed to it. That was between October and December of last year. And once it passed through the lower house, it then went to the Senate. So now the senators are basically debating and arguing over the bill. There's a lot of rights groups and a lot of immigration organizations and advocacy groups that are very much against this bill because of just the scope of it in terms of how much it changes and how unfair it really would be. So there are aspects of the bill which are also worrying people and worrying Canadians too, aspects regarding privacy concerns and so on, how much information the government can collect. So there's a lot of issues that these bills are facing. And one important thing to note is that they are still being debated. There's no guarantee that these bills are going to become law. It's still just something that could potentially happen if they agree to it and vote for it, but it has not happened yet. If Bill C12, which is the one that incorporates aspects of Bill C2, if that one does pass and become legislation, then yes, it can have some significant impact. So one would be right now, if a person enters in from the United States and if they make a refugee claim within 14 days, they can be sent back to the US and found ineligible unless they meet certain conditions. This bill would kind of change that on its head. So instead of the 14 days being the period in which you cannot make the claim, you would have to make the claim within those 14 days of your arrival. And if you don't make the claim within 14 days, then you'll be found ineligible. And there's a bunch of issues that come from that. So, of course, that creates this kind of arbitrary time limit for people to force them to make a claim as soon as possible. And I've seen a number of cases where people don't know what they're doing and they struggle to even figure out, or even just to get appointments with law offices, or to find people who can help them. People don't generally understand or know the law. Even people in Canada don't know about immigration rules and laws, for example. So to me, it's a bit unfair to give them such a short window. I think if they'd given a slightly bigger window, maybe even 3 weeks, 4 weeks, that at least gives a person some time to adjust and whatnot. So that's one issue. The other issue is, of course, this aspect of the 1 year kind of bar to making a refugee claim. But again, kind of weirdly enough, they've started the clock from ticking from back in June of 2020. So the way that the bill is currently worded kind of suggests that if a person entered Canada after June of 2020, so let's say if they entered in June itself or in July, they had 1 year to make a refugee claim. So it's kind of retroactively changing the law. So they'd have 1 year to make a refugee claim, and if they didn't, then that's it. They cannot make a refugee claim. To me, this seems a bit weird because if a person, let's say if someone came in July of 2020 for a holiday and then they went back to their country and then they suddenly had a problem now, which causes them to flee, that person could not now come to Canada and make a refugee claim because they came on a holiday a few years ago. So that to me, just as an example, seems very unfair to prevent someone from having a case heard because they randomly came to the country before. This could apply to children as well. So let's say if someone's a child who entered with their family in August of 2020 after the pandemic had kind of eased up a little bit, or in 2021, for example, 2022. So there's a lot of issues with that, with the timeline, and then also there's confusion as to when the provisions apply. So Bill C12, which again takes those aspects of C2, which are most important for refugee claims, it basically kicks into effect for any refugee claim made after May 26 of 2025. So for refugee claim, or I believe it's around that day. I could be wrong with the date. It could be May or June of 2025. But basically, whenever this bill of C2 was introduced into the Parliament, Bill C12 takes effect from that day. So if a person made a refugee claim after, let's say, May or June of 2025, and if they'd previously entered Canada over a year ago, then unfortunately they would potentially find themselves being ineligible. So there is a risk that people who've made claims over the summer of 2025, for example, there is a risk that if this bill does become law, that those claims could be found ineligible, and instead those people will be offered a different system. In my opinion, it would be the process that they would receive then. And I believe that's probably in the provisions itself, or at least will be in the IRCC policy. But so that could have a major impact on a lot of people who have made claims. It is important for people to be aware of it, but I would tell people not to panic at this stage, or to worry too much, because again, it's not yet law, it's still being debated. And we've still got a long way to go before it can become law. And there's a lot of people raising these issues with the bill, like some of the ones I just mentioned, where it just doesn't make sense. Where if a person traveled in 2021 for a 1 week vacation or something to visit their family, or even if they came for some other reason, why should they then be prevented from making a refugee claim several years later, if the problem and the reason that's causing them to flee their country is a recent issue that's arisen? So again, this is something that they did to target, in my view, international students and so on. But it's really not a problem that, at least from my office and from my colleagues, it's not really a problem that we see or deal with too much. Again, it's quite rare, at least personally for me, to deal with cases where someone's been a student and is kind of doing a Hail Mary, to try and stay in Canada with a different application.
Some people seeking legal aid assistance for when they submit for refugee claim,
Mhm.
and what are the pros and cons about that decision, and because when Canada, countries like Canada tightening the policies, what are the pros and cons about seeking?
Yeah, so legal aid again, that's actually because the agency that deals with legal aid, it's different from the government. It's like a semi-government organization. It's a quasi provincial organization. So they operate at an arm's length from the government. And that's from the provincial government, not even the federal government. So the federal government deals with immigration itself. If a person meets the criteria for eligibility under legal aid, and it's very strict, but if they meet the criteria, then they can get help with legal aid. Now, bear in mind, obviously, that means there's fewer lawyers to choose from, because not every lawyer takes on every case, and some lawyers are also very restrictive about which cases they accept on legal aid. Getting legal aid assistance, I would actually recommend people go onto the legal aid website itself, where you can apply online, and they have a pretty simplified process now for online applications. If you believe that your case is a bit more complicated, then calling them directly is actually even better, and you can speak with a caseworker who can get you set up. They have legal aid certificates for helping people who are going through the refugee claim process, so helping with like the basis of claim form, or with the hearing stage, or even with appeals, though there's a bit more restrictions and criteria around that, because the case has to have some merit. If they don't believe that it's a case with merit, then obviously they're not going to grant funding. So legal aid is absolutely, just like the aspect of being on Ontario Works, receiving social assistance or working. It's one of those things where it's a service, a public service. It's available to people who need it, and it won't change whether we treat all clients the same, regardless of if it's a legal aid client or if it's someone who's paying privately. We're still expected to do the same level of work and service for everyone.
Some people applying for their asylum at the airport after arriving. And what is the pros and cons about that, after having arrived in the land, applying and applying at the airport? Will it speed up the case, or there's somebody saying? So what do you see?
Yeah, I don't think it necessarily would speed up a case. But what it does do, there's different aspects and different risks involved with both stages. So one, if a person arrives in Canada and they make a refugee claim immediately when they arrive at the border, it can look good in their file because the person is seeking protection immediately, and then they don't have to answer the question of why they didn't make the refugee claim at the airport or why they delayed in making a refugee claim. If a person delays in making the claim, that can start to raise questions about whether they are actually afraid. If a person waits a month, 2 months, that can again cause the refugee board member who decides the case, or even the officers looking at it, to wonder why the person waited so long. So it's better not to delay. Delaying can actually be a factor that can cause a claim to be rejected, depending on the circumstance. So that's one aspect. But again, it's more an issue of making a claim with or without a lawyer. And so the risk with making a claim at the airport, particularly if someone doesn't really know what they're doing or is not prepared, that's the risk, because they will question a person, they will seize documents, they will inspect, and again, you're kind of at the luck and mercy of the officer. Some officers are very nice and friendly and accommodating. Other officers maybe not so much, right? There was a lot of, I think there was a recent article about the number of complaints and misconduct claims against CBSA officers, and they were significant, where they'd been credibly found to have committed some kind of misconduct. So of course, just like any law enforcement, you can have good and bad apples and so on. But with the CBSA, the difference is these are people who, like, they'll conduct interviews with you. Sometimes people are afraid. People always have that fear when approaching and talking to law enforcement, and particularly border officers. People will know that feeling when you land at an airport, and even when you have no issues and you're just a visitor, you can still get that fear and worry. So not everyone performs well in those kinds of conditions, and people say or do things that just don't make sense. Or people will say one thing and then say afterwards, "Oh, I really wish I'd told them the full story." So people who arrive at the airport and make refugee claims, that's great, and you can absolutely do it. But just be mindful that when you're talking to these officers, one, they're noting everything down, they're writing everything down. They can make mistakes, so you should make sure that they're writing everything down accurately, and always make sure to request copies of these documents, because again, sometimes they don't bother to give copies of documents. So the CBSA officers, the work that they do themselves, um, there's a variation in terms of the quality and so on, right? And there can be so many factors. Maybe they're swamped on that day. So sometimes when people make refugee claims at the airport, there are also different processes at different places. There isn't one uniform setup that they have. So sometimes they can fill out all of the forms with the person there and then, issue all of the paperwork, including a work permit, and send the person away. Or sometimes if they're busy, they will just take the bare information from the person and say, okay, go away, go find a lawyer, go find someone to help you with the case, and you can file your application through the online portal. That's where we kind of call it a semi-inland claim or a half-inland claim, because they've started the procedure at the border, but for whatever reason, maybe they didn't have time, maybe they're busy, or the system is down, they've sent the person away. Particularly, and those situations happen where there's less of an issue with the person's identity. Let's say if you have a family that's arrived, parents and two kids, are they going to be as big of a risk to the public or anything like that? No, not really. And particularly where they have their documents and you can verify who the person is. Whereas a CBS officer, if someone lands, and let's say it's an individual on their own and they're quite young and they're traveling on fake documents or a false passport, those types of things obviously are going to flag the concern of the border officers, and potentially lead to a person being scrutinized a lot more. So they have obviously a job to do, but yeah, it kind of just depends on the individual themselves, and knowing that what you tell the officers, everything's being recorded, and you should listen carefully to the questions and answer them carefully and truthfully. And if you're worried about that, then yes. And if you have the ability to enter Canada, let's say if you have a visitor visa or some kind of visa that permits you to enter, then in my opinion, I usually tell people it is better first to enter, seek legal advice quickly, and to find out what your options are, because that way, obviously, you're going and armed with more knowledge. And again, every case is different. So seeking legal advice first and foremost can be better in some cases. And that is what we recommended anyway.
Yasin, you have seen so many hundreds, maybe thousands of cases. What is the general take or advice you can provide to the people? You everybody has a story when it comes to submitting the asylum claim and all. So when going through a hearing process, what they have to be, like what why most why the when it comes to the cases which getting rejected, what is the general pattern that you identified, and what is the general pattern you identified when the cases which won?
Hmm. Yeah, so I would say that it's always one of the things, and this kind of applies to a lot of things in Canada, at least based on more of my own experience as well, is you should always be on top of your own case as well. So like if there's something that you're actively having, if there's a refugee claim that you're having, or let's say if you're going to your doctor for an issue or whatever, you should keep on top of it and keep on top of your own case. So stay informed and don't, sometimes people rely on others, so like either social workers or their interpreters and things like that to help them with cases, and that's fine. Like there are a lot of people out there who will help you, and obviously we will do our best to help as well. But being prepared, right? So being prepared, we have cases where from when we help and draft a basis of claim form and narrative for a client based on their allegations and so on, we'll help people to draft those documents so that they have something that it reads clearly, and someone can read it and understand what happened to this person. But then if you don't look at that document again, and then you have, let's say your hearing comes up 2 years later on, if you haven't bothered to look at that document before you go into the hearing, or if you haven't bothered to look at the documents that are on your file, or if you don't even know which documents exist in your file, that's a big problem, right? And it's, I tell people, going into a hearing without looking at those documents, like looking at your own story, even though it's your own statement and it's something you've written, if it was 2 years ago, it's very difficult to remember exactly what you wrote. And people have generally quite bad memories. We have a tendency to um, misquote dates, or to give the wrong dates, or to say the wrong things, or to forget them altogether. Sometimes people mix up events together. So, human memory is really bad. Particularly when it's been another 2 years or a year and a half since you wrote an initial document. So it always helps to refresh your memory, to remind yourself, well, what did I say? What did I initially give? And I always tell people as well, like sometimes I watch a lot of US courtroom documentaries and stuff, and you can watch, in the US they broadcast some of their cases, and it's always interesting to see how they try and get someone in a bind, right? And even where someone's telling the truth, people can mix up dates, or not remember things correctly, which can lead to doubt in the other person's mind. So if someone's telling a story and then you get something wrong and you start contradicting yourself, even if it's a minor thing, it can cause the person who's listening to you to doubt whether you're telling them the actual truth. So I tell people, be on top of your case. Obviously, if you have people helping with it, that's great, and you should get help for that. But at the same time, make sure you know what's going on. So make sure you have a copy of your basis of claim form. Make sure you have a copy of your client application summary, even if a lawyer or someone else is submitting on your behalf. Now, obviously, if you have a lawyer submitting your refugee claim on your behalf, you won't have access to the portal itself, because we as lawyers have our own portal with all of our clients' information. So I sometimes have people asking me and saying, oh, hey, can I have access to my IRCC portal? And I'll have to tell them, no, sorry, that's my portal, and it has a bunch of other people's information on it. I can't share that with you, but I can give you, all of the documents that immigration has sent, or I can give you a screenshot of your application directly. But there's no new information. Once a claim is made through the IRCC portal, and once that information is transmitted to the refugee board, nothing further really comes out of the portal itself, other than perhaps some documents from immigration regarding like a person's prior visa application, or if the government is intervening. Those are things that can sometimes come through on the portal. But yeah, so maintaining kind of an understanding of your own case and being on top of it is really important. Gathering documents quicker, like doing it as soon as possible, um, that helps with a person's case, because then the person is prepared. If a person is ready to proceed and has their case in order and has their documents ready, it makes it that much easier for the board member. Well, it makes it that much easier for us to help them, but it makes it that much easier for the board member to look at the case and say, okay, this is what the person's alleging happened. They've given me the documents to show that these things, different elements have happened. I'm willing to believe them, right? I'm willing to believe that they're telling me the truth. So we see that with people who do take it more seriously and do take it, um, do maintain kind of an understanding and a priority with this type of thing, that helps them a lot more. But at the same time, you do have to get on with your own life in Canada as well, right? And we don't want people worrying about these things all the time. That's not good for a person's mental health. So particularly for the clients that we have and we deal with, I always tell them, look, if we're not worried about it, and if we're not panicking about a case, that's a good sign, because it shows that there's no surprises or issues in the case. We generally will, always tell someone where there is a problem, or if there is an issue in the case that has to be dealt with, we'll try and raise that as quickly as we can. And most, um, even the lawyers and the paralegals and consultants out there, I would, again, if you're working with someone who knows what they're doing, which is important as well, that you have to be comfortable with that. Just in the same with any other field, whether you look at an accountant or a doctor or whatever. So if you're working with someone else, and if you're going to trust them, one, make sure that you know who they are and what they're doing in your case, but at the same time maintaining that awareness yourself as well. Yeah.